we have got our expert panel. We have 6 that will be on the panel. We're waiting for one of them, Benjamin Taylor, will be joining us a little bit later in about 15 minutes or so. But I want to introduce you all to our esteemed panel of legal experts here, and every one of them have different insight and perspective. Now, Rachel Smith, special prosecutor in the Idaho trial against Lori Vallow Daybell. She's the founder of Smith Law and Consulting, focusing on assisting prosecutors nationwide as well as other civil matters. Her prosecution work includes appointments on sensitive and complex litigation. Taylor Larson with Ellsworth Family Law. He's been practicing here in Arizona since 2016. He was the former attorney for Charles Vallow. Charles Vallow, the victim in this case, who confided in Taylor as he was going through marital issues with Lori Vallow at the time, wanted her to get mental health and mental help for her mental health, I should say. Taylor Larson helped Charles file those divorce papers that were just, I mean, so fascinating to read now, years later, as he was asking for help and saying that there were major concerns with his then wife. And we have Susan Constantine, body language expert, jury consultant. She has covered so many trials. If you are being deceptive in any way, she will find out. Trust me. We have Tom Evans, juror number 18 in the Lori Vallow trial in Idaho. I mean, he didn't expect for his life to take such a turn, but he was sitting in that jury box, but he ended up being an alternate juror, even though he heard all the evidence, and he ended up writing 2 books on the Vallow Daybell saga, Money, Power, and Sex, the Lori Vallow trial, and Chad Daybell, The One, Mighty, and Strong. And finally, he's a retired Maricopa County Superior Court judge, a former prosecutor with the Maricopa County Attorney's Office, and former U.S. Attorney for the District of Arizona, spending decades in the courtroom. He is the judge, our judge, Mel McDonald. Thank you guys for joining us. We appreciate you. Closing arguments. I mean, you have to be a little bit hyped up for this. It is a serious matter, but we are going to see how Lori Vallow Daybell somehow, is this her testimony in some way? She decided not to present any evidence. Rachel, let's start with you. No surprise, she has declined now 3 times, but what do you expect to see as we get into closings in just a little bit?
Well, it all at this point kind of all comes down to the jury, right? And we're going to see both sides try to put forward their point of view to the jury. We're going to see how well jury selection turned out at this point. We also, we are going to see Lori take the time to try to sell what she believes the jury needs to hear. Lori's going to put forward her point of view, and I think this is where you're going to see her try to testify. Lori's going to have the last word if Lori can can get it in, and then we're going to see the prosecutor put forward and try to get out and help the jury understands very complex legal concepts, conspiracy, self-defense, some of the hardest legal stuff out there.
Now, in opening statements, Lori again and again said the evidence will show, the evidence will show, and the evidence will show that self-defense is not a crime. Now, she didn't present any evidence. Judge, what does the evidence show in this trial?
The evidence is compelling. If I were the prosecutor making the closing argument, I would lay out, starting from the beginning of their relationship. There are smoking guns after smoking guns in this case. The correspondence between her and Chad, the hypocrisy of some of the accusations and cross. I would make a point, if I was the prosecutor, to point out the things which Lori said the case would show that didn't. She opened that door. She said it will show this, it will show that. And she didn't show anything other than probably a lot of hypocrisy, and clearly showed that she was bright, intelligent, articulate. I think the case will go to the jury later this afternoon. I would be shocked if the jury is out beyond tomorrow.
Now, this has lasted for less than 10 days, really. Let's set the scene for you. We had dozens of people line up this morning to get in. People were turned away. We've got local media, we've got national media. We know the type of publicity and attention this case has garnered through all the trials. We've got a reporter going live right now outside the courthouse, and the jury's just getting a lunch right now, getting ready to make a huge decision. Tom, that brings us to you. You sat in that box and you listened to all of the evidence, and even though you weren't in that deliberation room, just what was it like for you to hear closing arguments in that trial in Idaho?
Yeah, it's hard to sit there. I hope that this jury stays awake actually after those jury instructions, and I think the closing arguments will be a little more exciting, and maybe they'll wake them back up.
Yeah, obviously the instructions are very, detailed and complex. But closing arguments, I mean, what stood out to you from the prosecution? Obviously, and Rachel was in that courtroom, but just what stood out to you in closing arguments, whether it was from the state or the defense in 2023?
I think that case, it was pretty cut and dry. There was a lot, just I guess, a compilation of evidence that added up to only one conclusion. So my mind was pretty well made up by that time before we ever heard closing arguments.
Susan, what are you looking for in the body language, the demeanor from the so-called Doomsday Mom this afternoon?
So she's kept herself pretty well in check. I think we could all agree with that. A few times of being snarky, a little condescending, sarcastic at times, argumentative at times. But now the ball's back in her court, so no one is going to be asking her any questions. So she's going to be totally in control. What they're going to be looking for, in my personal opinion, is she showing any sort of remorse? I mean, her husband had died. He was killed. So is she going to be showing any genuine remorse whatsoever? The things that I would be looking for is her overall demeanor is so flat. I think that in itself speaks volumes, because it's not so much of what you see, it's the absence of things that we don't see. So the fact that she's not showing any sort of genuine concern, emotion, all of these are all the subjective part of it, right? They're subliminal messages. The other part of what I think they'll be looking for is how well she's able to articulate. She's very organized. She's very precise in a lot of ways, in her own way. What does that tell them about her personality and the fact that she could be a part of this conspiracy to do what allegedly she had done? Because this in itself takes a person that's very smart, very methodical, very organized in her thoughts. So in that respect, it may play against her, but who knows? All it takes is one juror, right? And I think we'll all agree it just takes one juror, a holdout, and here we go again.
And I think we can all agree that it would be shocking if she did show any emotion regarding Charles Vallow, if she said that she loved him. But we know that she has already said this is a self-defense claim, and that it's almost like Charles was the villain. She makes him seem to be in her case. So Taylor, I gotta ask you, waking up today, you've been down this road, this journey for 5 years. You were in that office when Charles came to you and said that he had problems with Lori. He told you that if anything happened to him, it would be Alex and Lori. And now here we are today for closing arguments. What is it like for you full circle?
Yeah, it's, Justin, it's exciting to finally be at this point in this saga that's drawn on for, like you said, 5-6 years now. But it was in this office, this that I'm sitting in right now, where he foretold of how he was going to die, and that it was going to be, Lori and Alex who did it. So to finally be here, to finally, hopefully get some justice for Charles, it's a great moment, and I'm hopeful that, like the judge said earlier, it'll be a quick deliberation, and that we'll get to close this chapter here today, and it won't drag on to tomorrow. But even knowing that if it does drag on to tomorrow, I don't think it'll be long for tomorrow. I think it'll be a shorter, a morning verdict. But hopeful, remaining hopeful, and excited to see closing arguments. Excited to see if Lori's going to inject any of those emotions that you talked about. Will we see her put on the theater that she kind of put on at the opening? But I don't expect her to, because of the way that she's handled herself anytime she's talked about Charles in this trial.
Now, during instructions, the judge mentioned this statement that sort of when, like, even if you are at the scene of the crime, it doesn't make you guilty of that crime or that conspiracy, trying to explain that we know she was inside the home when Charles was shot and killed. She left the scene. But Rachel, if you could take us into that conspiracy to commit first-degree murder charge in that language, you think something like that, the jury knows she went to Walgreens and Burger King, but it doesn't mean that she had to be the one to call 911 and do CPR on Charles, even though many would think you should do that for your husband.
You're absolutely right. Jury instructions of conspiracy can be very confusing. We will expect the prosecutor to kind of walk through language. The defense is going to focus on some language the judge used, which is called mere presence. Merely being present doesn't mean you're guilty of a crime. The prosecution is going to focus when they discuss those instructions on contribution to the idea, the planning, the agreement to have someone killed or to commit an act. So it's going to be about her contribution, her encouragement, her aiding of Alex before the act of murder, and then the consciousness of guilt she showed by her actions later. So those instructions were legal definitions that the jury will have to wade through, but we can expect, like you focused on, the defense is going to focus on merely being present when someone is shot doesn't make me guilty of conspiracy. And we're going to hear the prosecutor talk about those texts. It's all coming ahead to this week. Stay close to me. You'll be like Nephi. Those statements which show the planning, the intent, and her aiding and encouraging Alex in murdering Charles. So the prosecutor's job will be to take the legalese, all those legal instructions that courts spent years working on, and translate them into the evidence. And I think we're going to see that from Trina Kay. And she opened with the language she needed, which is stay close to me. It's coming to head this week.
Judge, what are you looking for in Trina Kay? As she's going to go an hour plus, and I assume that she's going to have some visuals to bring back up on the screen. You've been in her shoes.
Yeah, I think you start, when you look at the Dave event, there are facts that are absolutely overwhelming. Mind you, to have your husband shot in front of you, and you take your kids and go to Burger King or wherever they went, and then to buy sandals, you don't call the police, you don't do CPR. Any parent on the earth, if your child witnessed this, and Tylee was there, you would be traumatized. And yet you look at the videos of her at the scene from the body cam, smiling, indifferent. That is the starting point. And then you build the blocks before the relationship with Chad Daybell. I would have given $1,000 to have a video of her face when she found out the $1 million insurance wasn't coming in. These factors, piece upon piece, are going to be overwhelming. That's why, in my view, the instructions can be challenging. They can be cause some confusion, but in this case, no. There are too many chances that she can't escape. And interesting enough, I come back, the only emotion we ever saw from Lori was in the opening statement, with her daughter there, with this cold-blooded nature of this killing, no emotion. I suspect we'll see some more tears as part of the performance in the closing, but she cannot get away from the evidence. It will be a speedy verdict, and I'm convinced it will be a verdict of guilty.
Hey, Tom, you were in the courtroom in Idaho for sentencing as well. You wanted to be there. to see Lori Vallow Daybell. She was sentenced to 3 life sentences for the murders of J.J. Tiley and conspiring in the murder of Tammy Daybell. Now, in her allocution, she does get religious and she does get emotional when she talks about her children, mainly Tylee Ryan, like Judge Mel mentioned. Do you think we could see some of that in her closing arguments, like she will use the name of Jesus Christ and, she's just a religious person? Is she going to testify something like this?
Yeah, it's very possible. I mean, this is her opportunity, right? She could try at this point to convince the jury that she is a translated being. I'm not sure if she's going to do that. So far, she's going to back off of that. But if she's ever going to do it, this is the time. So we'll see.
When you were listening to the evidence, what weighed out more heavily to you, religion or the money element?
In this case or in the first?
I would say the first case. Obviously similar as far as what the motives are being described and alleged by prosecutors.
I think for me personally, it was more, it was less the money. It was part that, but I think it was more just her crazy religious ideas. Yeah, I would have to say more of that.
Susan, I gotta ask you, and I'll ask the other prosecutors and Judge Mel as well, but as far as the jury, how much leeway they get in discussing their schedule? I think everybody is very curious of what we expect this evening, but by the time they get the case, it's probably going to be 3 p.m., 4 p.m. Pacific time. Who knows?
Well, the first thing they're going to do is they're going to select a juror foreperson. That's what they're going to do when they first get into deliberations. Oftentimes, they take a first ballot vote, to see how far they away from one another. So it could be very quick. We could see where they are as far as their baseline is concerned. Do we have a few people that are undecided? Sometimes, they set the rules. So there's no set of rules because they get to decide what the rules are and how they're going to do it. So how they end up in that procedure, the only way I can give you a description is through what I've seen in mock trials and focus groups, and they're all different. And sometimes they get really argumentative when they're in there, right? That some you've got like the Hatfields and the McCoys. Sometimes you have a division, but it really is based on that juror foreperson and their leadership qualities to be able to bring them together and to be able to make every single one of them be feeling that they're heard and they're validated. And then, of course, if they've got someone that is what I call a stronghold or someone that has a varying opinion, then they've got to go back into the evidence. And then what they do is they discuss it. But, it's really interesting, and I'm sure that all of my panel has seen it behind the scenes, and I've conducted focus groups and mock trials, and it's not a clear cut, this is how you do it, and we all do it the same way. Every single case has its own nuances, but I think that they're probably going to get back there and go, you guys, this is like the craziest thing I've ever heard. What do you think? I'm sure that there's going to be a release because they haven't been able to discuss this case at all.
True.
And to the point, whether it's the money or whether it has to do with the crazy story about the zombies and all of the kind of stuff. If I were a juror back there, I would be kind of stuck into this whole zombie thing, saying this person is absolutely nuts. I think, to the judge's point, I think that we're going to see a verdict come back very soon. I don't need, it may even happen. They may stay later. A lot of times when they get started, they want to just, if it's a first ballot vote, most are coming up with guilty or versus not guilty, that would determine whether they're going to go into the next day and go home. We don't know. That's the thing is about juries. We just don't know. We think we know. All we can do is do our best. But what happens behind closed doors has always been a mystery.
Yeah, to be a fly in that room, that will be something. And also to know the makeup of that jury. Every person is different, so we don't know exactly what we're going to get. But Rachel, take us back to 2023. The jury gets the case. And I remember they got pizza for dinner in Boise, Idaho. And then they end up going home for the night. Just if you could, were you surprised that, do you think it was a quick verdict or did it take longer than you thought?
In my experience, I thought it was a quick verdict. I think there were some on the team who were depressed that it took as quote unquote long as it did, but I thought it was a quick verdict. They had multiple counts. They had weeks worth of evidence to think. And it doesn't surprise me when I hear Tom say going into closing argument, several of them had their mind made up. That most juries, if the prosecution has done their job going into closing arguments, they really, most of them will have their mind made up one way or another. So no, back in 23, I thought it was a relatively quick verdict. You got to remember there were 3 sets of crimes they heard about and had to consider. They also had to consider the overall conspiracy spanning a year plus. So the amount of evidence that existed in Idaho and what was at stake was a lot greater than this jury has. This has been kept very narrow, very focused on Charles. If we don't have a verdict by tomorrow night, then there's something going on in that jury room that we're concerned about. I agree with the judge. The prosecution's done it. The evidence there, it's very clear. So we should have a quick verdict.
Hey, Taylor, I got to ask you, because people watching have asked, why weren't you brought in as a witness for the state? I think your insight has always been, I've been talking to you since 2020, your insight into what Charles was going through. Do you think, you're a lawyer too, why would they not, give you a call?
Yeah, I've been curious about that, Justin, because I was waiting for someone to call from the prosecution. I was waiting for, even law enforcement to call me. Like we talked about a little bit last week, I don't know if it was the attorney-client privilege that kind of scared them away. But, like I said last week, most of the stuff was waived because Charles told me, if this happens to me, it was Alex and Lori, and tell everybody, because I won't be here to tell it. And, it's interesting. I saw a lot of watchers are wondering, why wasn't Charles's body cam brought in that we're seeing on the screen right now? And obviously hearsay kind of keeps that out. And so you have to bring in someone, and, they could have brought in me to say, hey, this is what he told me 6 months ago. And he foretold of it, but that, I don't know if that would be kept out as well. But yeah, it's a question that I've always had on my mind throughout the saga of the last 5 or 6 years.
Well, we're glad to have you on as our witness, taking the stand for us every day on the panel, Taylor. All right, we've got Benjamin Taylor on the panel on deck, criminal defense attorney here in the Phoenix metro area. Benjamin, just your thoughts going into closing arguments, what you expect to see from either the state or Lori Vallow Daybell.
Lori Daybell has to hit a home run. She has to look at those jurors in their eyes and hopefully convince 1 or 2. As we talked on the panel earlier, this is going to be a tough case. It's probably a quick verdict. However, if she can convince 1 juror, this 1 juror, she just needs 1, right? So maybe she's been in this jury for the past couple of weeks. So he could probably key in, maybe 1 juror is nodding towards her. Maybe 1 juror is smiling towards her. Who knows what's going on in there? But she's probably going to key on that 1 juror or 2 jurors to hopefully convince them to go back in the jury room and say, hung jury, or I can't decide, I'm confused, and I can't, complete my decision here. And we'll see what's going to happen based upon the jurors' questions. The jurors' questions, if they have questions during this deliberation, is going to, we'll see which way they're leaning towards. But Lori Vallow better try to hit a home run by convincing 1 or 2 jurors to have sympathy for her or something in order to get a hung jury in this case.
Or more like hit a grand slam. Have you done that? I'm assuming in the courtroom you build a chemistry with one of the jurors or a couple. Maybe it's just a smile or not. I don't know. But just, Benjamin, is that what you're talking about? And then you zone in on them with your last chance to speak?
Yes. So every time Lori Daybell has been done cross-examination, the jurors are right there to her right of her. So she can look and see how the jurors are reacting to her questions, how they're reacting to the witnesses' statements. So if you see a juror smiling at you or nodding towards you, then maybe juror number 5 is on my side. Maybe juror number 8 is on my side. But if you see the jurors when they're like turning their head or going like this, or maybe even falling asleep. In some cases, when the evidence or they don't believe you, some jurors will just close their eyes and just you're done. And that happens in real life every day in trial. So Lori Daybell better have been paying attention for the past 2 weeks and looking at what jurors might be nodding at her, what jurors might be even having a glimpse of even liking her, in order to try to, like you said, Justin, hit this grand slam, because that's what she's going to need. She's going to need a grand slam in order to even have a chance of getting past this guilty verdict and trying to get a hung jury in this case.
Money Mel, you've got to have some stories from the courtroom. Looking at those jurors, you got to give us something. Is Benjamin speaking the truth here?
Let me pose this one question. Look at, if you're a juror and you're trying to see whether there's innocence here, looking at Lori Daybell, what is one fact that you can come up with that is favorable to her defense? In other words, we're talking about a jury hanging. It can't be her emotion at the day. It can't be that she's distraught. It can't be that she doesn't call 911. It can't be because the religious, he was possessed with demons. So when you look at the possible juror that might hang the case up, the problem with it, that is, there's nothing to hang it up. The only conceivable thing that helped her is the delay in getting the case prosecuted. And I think part of the problem was Kylie, on the day of the incident, apparently talked to the police. Lori apparently had her trained, and Alex did have a minor wound on his neck. But the fact of the matter is, when we talk about, well, yes, a jury can hang it, but to hang it, there's typically got to be something really significant to hang it on, and there's not. Her despair when the $1 million is going to somebody else, eliminating people left and right from her life that are a problem. I've got to believe the jury's going to wonder, where is Tylee as a witness in the case? She was in the house, but Lori didn't call her. Sure, she doesn't have to, but why? The reason I think the chances of a hung jury are remote is there's nothing, absolutely nothing, that's been brought out in this trial that's favorable to Lori Vallow.
Tom, when you were in the courtroom these past 2 weeks, did you see any, how would you say the jury reacted to a lot of this overwhelming evidence, specifically the religious stuff, the dark and light spirits?
Yeah, I don't think they reacted too well to all of that. But, so the way Chad and Lori operate is they throw out an impossible premise, right? And see who falls for it. That's their tactic. And then whoever falls for it becomes a follower of theirs. And so I'm guessing, I don't know what the number is, it's probably 1 in a million people would actually fall for that. And she's got a pool of 12. And one of those people has to be on that jury for her to be able to win this. And it's possible, it's just really unlikely.
Was there a witness that really stood out to you throughout this trial, out of the 90 witnesses, Tom?
I think just like in the trial in Idaho, it's not one witness or one thing that does it for you. It's an accumulation of all of it.
Yeah, that's Susan. What would you say about that for a juror's perspective?
Well, actually, can I kind of back up a little bit? Because I'd really like to speak on what we would be looking for in the juror that are either on board or off board. Do you mind if I speak to that?
Yeah, sure.
Okay, so some of the things that I look for when I'm in trial and I'm watching the jury is those areas of these little micro expressions. And I know we've heard about micro expressions in the past, but there are these very, very little subtle micro expressions that just kind of leak out. And they also go back to normal very, very quickly. And what that's doing is it's telling me subconsciously how they're actually feeling about a specific witness, parts of the evidence, how they feel about her. So what I'm looking for are areas of what, if you can see my face where my eyes all of a sudden become slightly narrowed, right? Or maybe my eyebrows lift and I'm surprised. Maybe I might even show a little micro expression of disgust and maybe a contempt, facial expression, eye rolling and contempt. So there's these little minor little subtleties that I look for that's telling me about emotions and cognitions. And then what I do is I record who's doing what when. And is there a pattern within specific jurors that are actually doing it? What are they hearing? Who's testifying? And how they're actually feeling about it at that moment? Because that's the stimulus, that's the probe. How are they immediately responding? So those are the kind of things that I would be looking for that would kind of give me a preempt on how that jury may be thinking, and how that would potentially end up as their vote at the end of the day. So also, I'd like to speak to about this. Maybe a holdout juror, as the judge spoke about. I sat all the way through the Casey Anthony trial. I covered that case from beginning to end. And there's also, I never thought for a million years that she was going to be found not guilty, right? But also, keep in mind, she is in front of that jury the whole time, speaking, and she's demonstrating, and her presence is known. There is something to be said about that familiarity, where a juror becomes immune to that person and seeing them as far as guilt or innocent. So I don't think that we should downplay that. I think the judge is correct, but there's also a phenomenon too, where I saw in the Casey Anthony trial, like how in the world could that jury possibly think that she was not guilty? And the reason behind it was because she was faced directly in front of that jury the entire time. And there was a sense of familiarity that happened there.
Interesting. Rachel, I want you to take us into your courtroom at the time in 2023. Did your team huddle up after certain days and notice that jurors were picking up and starting to understand this very complex case? Did you guys have notes on that, or was it just focused on the witnesses?
No, we did as a team, or more specifically, Rob Wood, who did the closing argument, myself and a couple of people, we sat down and said, okay, what did the jury seem to react to? Are we in danger of overdoing it? It became very clear to us that the jury had a visual and physical reaction to the pictures of both Tylee and JJ. And so that became a choice. Do we use those images again and walk through as much of the science about how they died as we had planned? And so there was some concerted discussions on what should be caught out of closing arguments, because you don't want to be perceived as overdoing it. And the jury's reaction had a role in how much Rob covered and how much the team asked Rob to cover in closing argument. So absolutely, we pay attention. We would look at the jurors to see how they were responding to certain evidence. I think sometimes that worries the jury, like, why are they looking at us? You're trying to get a gauge. How far do you go? What do you cut out and what do you key in on? And Rob shaped a lot of his arguments around how do we think the jury will see this and what makes the most sense for helping a jury see and understand how and why a mother would participate in killing her children and killing her boyfriend's wife.
Yeah, it's a very emotionally heavy case, because I just remember being in that room for the graphic evidence that was shown. You could hear people crying. It was quiet, and it was just, you could feel that heaviness. It's something that you don't forget. This case is a little bit different. Obviously, still a man who's been shot and killed and gunned down after going to pick up his child, JJ Vallow. Rachel, I want to ask you this. Earlier today, Lori had issue with the video that was presented in court regarding her an interview with Chandler PD, and she said that it wasn't the full interview, and confirmed that it was excerpts. Is that a common thing? The prosecution had to get rid of portions that included hearsay regarding Tylee Ryan, and she was picking at this for some time.
It is not unusual that the defendant will object to evidence being redacted and not redacted. Chopped up, they'll sometimes say, and they will sometimes argue, well, that's not telling the whole story. That's not providing the whole narrative, or that it's editing the evidence. Had she had a defense attorney, those objections would have been raised before the exhibit was admitted. They would have been raised during her cross, and then perhaps most judges I know that if there's a debate between the parties about what comes in and what doesn't, the judge expects the parties to either work it out or you have a hearing on what else should be there. So the judge was very clear with Lori, look, any of these concerns that it's not the whole statement or it's not the whole story, the whole exhibit, your time is run. You're out of time to change it that should have been brought up on cross. It's example 5001 of why Lori Vallow is her own worst enemy.
Yeah, Benjamin, how many times did you see opportunities for an objection where you're watching and you're literally saying it out loud as a lawyer?
I mean, tons of times when I was watching it, I wanted to say object, object. And she does have an advisory counsel there who's sitting next to her. I'm sure who's like, maybe nudging her arm a little bit to say object. But ultimately, Lori Daybell, she is her only, she's the main attorney. She's her only attorney. And she has to be able to articulate and write briefs and go in front of the judge and jury like any other licensed attorney in this nation. So unfortunately, that's what everybody on the panel has been saying. If she had an attorney, this case might be a little bit different today. Evidence being presented, cross-examination, but she's her own worst enemy by not having an attorney in this case.
Judge, if you were in the defense's shoes, how would you have been objecting throughout this trial? Where would you pick at?
One of the things that's important for your listeners to realize, the case that's being tried in front of this jury and this judge is only a small piece of what's really happening. There are appellate courts, there's the Supreme Court, there are federal courts. These cases often go through after that. That's why you have a court reporter there. That's why you make a record, because eventually that record will be reviewed. And as everybody on the panel has recognized, it is catastrophic when you represent yourself and points of error can come into the record that you don't object. The law is clear that you thereby waive the ejection. So, for example, hypothetically, if there were parts of her interview that really should have been in or should have been objected to that could have constituted error, you make a record at the time, not only for this judge, but for the Court of Appeals, the Supreme Court, the federal court, sometimes all the way to the Supreme Court. That's why a person that represents themselves has a fool for a client. If you don't have a legal background, you don't recognize it, the advisory council cannot help her. And so the bottom line, all of these things work against her and eventually, I think, create a record that will be sustained not only with the conviction in this case, but by the appellate courts.
We have about 8 minutes left until the jury comes back into that courtroom. Taylor, what do you think has been the most damning evidence against Lori?
I'll go back to opening statements, and I'm sure we'll see it a little bit in closing statements, but the most damning thing for me has been that they planted the bat on the wrong side of Charles, that he was left-handed, not right-handed, and the gap in calling 911 after, and the second shot. Those are the three things that really stuck out to me and really kind of make me emotional, knowing that, Charles may have survived that first shot if it really clearly was self-defense, which we all know it was. But I think that those three things are going to really true for the jury.
Hey, Susan, you brought up the Casey Anthony trial and how the jury just they got to know her. They got to see her and feel her as far as what, she was like. Do you think that could be the case because Lori has been acting as her own attorney, talking to witnesses, talking to the judge, wearing civilian clothing?
I think it can go both ways. They're going to either hate her, or they're going to be some people say, she's got a lot of gall to be able to do that. But I think, it depends on how each person processes that information differently. And that's what we have to really understand about jurors. Everybody comes with their own backgrounds and their own beliefs and so forth. And then it's how they actually are processing that information. But for me, what I'm seeing is the fact that those jurors are saying, no, Kylie, the son is not there. The visual impact of her smirking and smiling, her casual nature of after it happened, going to the store, getting the flip-flops, all of this is a visual presentation. 65% of jurors are visual. So when you think about how many people are visual, that means 7 people on the jury panel are going to be seeing these videos and they're going to say something is really off. And I would assume that they would know that an innocent person does not act that way after their children's father was just murdered, especially right there in front of her.
Rachel, if you're Trina K, what are the visuals that you would want to show to the jury as you go through this hour of closing arguments?
The visuals are the things that Judge Mel has highlighted, Susan's highlighted. It's her conduct afterwards, her laughing, hi neighbor, after the death of her husband. You're going to present the picture and the angles and the trajectories of how Charles was shot, because that evidence is powerful evidence of premeditation. There's no reason to stand over somebody and shoot them a second time in a downward angle in self-defense. So you're going to see the visuals of Lori's attitude and demeanor, which reflects her desire for Charles to be dead. You're going to see the evidence that shows us it was premeditated murder, not self-defense. And then you're going to see the visuals from the text of the motive and the reason why she wanted Charles gone.
Yeah, I put this out on X this morning. When do we get a verdict in this trial, tonight or tomorrow? Majority, 56% people believe it's going to be tonight. Tom, what do you think?
It's hard to say. I think it could be, but I also think that the jurors are going to go through very carefully the instructions. That's why it went overnight in Lori's trial, is they wanted to be real thorough, go through, and the instructions were complicated. And that's just how long that took them. So I don't know how, this is a simpler case, obviously. So maybe it'll be a little quicker, but we'll see.
Okay, how about you, Benjamin? Benjamin? Susan, what do you think?
I think that they may go home today, get a good rest, come back tomorrow morning if they aren't already still ready to go and want to go home and get this thing over with. But I think tomorrow they may take a fresh start at it, and then we'll get the verdict either late tonight or tomorrow if they decide to stay late. So I don't think it'll go beyond tomorrow. Taylor?
Yeah, I've been kind of worried because my schedule tomorrow, I have 2 court hearings tomorrow, but I was able to clear it. So I think that tomorrow morning that's my prediction.
So they'll get refreshed tonight, and that's what you're thinking. All right, how about you, Rachel?
I agree with the others. I think they'll, in my experience, jurors are very conscientious. If they've made up their mind early, they're going to want to make sure that they don't send the wrong message. They're going to make sure they show they're thorough and conscientious. They're going to go through those instructions. They may want to get a good night's sleep and face it tomorrow morning.
All right, Judge Mel?
I think it depends a lot on when they get the case. If they got the case at 3 or 3:30, I would suspect that they may want to stay late. Clearly, and I think from the standpoint in the juror's heart, we don't want to walk in and walk out in 10 or 15 minutes. We want to let the world know that we discussed it, that we deliberated it, that we went over the evidence. But there's nothing really that's going to create grave challenges. So I think if they get it by 3 o'clock or 3:15, there's a chance it could be tonight. But I think probably if it's late, I would agree probably tomorrow morning. If it goes beyond tomorrow, I would say there's a problem, but I can't conceive of a problem in this case.
Yeah, if it goes into tomorrow afternoon, I mean, we may be thinking what's going on in there. You all, thank you so much for being here on Closing Arguments Day. We appreciate you, and we'll see you in a little bit. Thank you so much to our panel.
Thank you.